Okay, this is in the matter of Hillsdale County case, Kareem Healthcare versus Shoal. Counsel, state your appearances, please.
Good afternoon, Your Honor. May it please the court, Allison Oliver on behalf of plaintiff.
Good afternoon, Your Honor. Christopher Morris for the defendant.
Allison is spelled A-L-Y-S-O-N. Oliver, just like
it's
musical.
Yes, sir.
Just like the musical.
Right.
And what was the second attorney?
Christopher Morris.
Morris?
Yep.
Okay, thank you.
Okay, let's see. I think we've got a couple motions up this afternoon. And I saw a proof of service. Unfortunately, this stuff doesn't show up on my docket like a Jackson County case does, which usually has the name of the motion. And I know I saw it somewhere. There was a motion to dissolve the temporary restraining order, as I recall. And I guess a motion to turn it into a preliminary injunction, or I guess I actually read permanent injunction. I guess I'd be interested in hearing the motion to dissolve first.
And Judge, just so you know, and I, not to speak on behalf of defense counsel, but I think he also has up a motion for partial summary today as well.
I saw a motion for partial summary in the file, but I didn't see anything noticing it for hearing. In any event, I read it, so let's go ahead and hear defendant's motions first.
Thank you, Your Honor. That was noticed on October 6th for today's date. The partial summary just...
I'm not doubting your counsel. I'm just telling you, for whatever reason, they have to set up a dummy case file here for it even to show up on my docket at all.
Understood.
And it just leaves much to be desired.
Well, I will ask you, did the court have a chance to review my brief in support of the motion for partial?
I read everything.
Wow, okay.
I read everything that was submitted to me.
And then you went on to War and Peace, is that correct?
Yes. I think I got up and got some more coffee at that point.
Fair enough. So the basis for the motion is quite simple, Your Honor. This is an employment case. The plaintiff employed defendant as a family practitioner. He was doing, he's a PAC. He's not a doctor, but he was performing medical care of patients. The clinic where he...
And let me ask you, this employment agreement arose in conjunction with the plaintiff's purchase of his practice?
Correct. Defendant sold plaintiff his practice. The building, the walk-in clinic existed prior to plaintiff's purchase. My client was actually reporting to a different physician at that time, and that physician retired.
And at that point, he had patients, but without a supervising physician, he couldn't maintain the practice?
That was not the issue. It was all set up to dovetail together so that the practice would transfer as it ended up. It never went down and was not in danger of closing, but it was all part of the transaction.
All right, I was just trying to understand that. It just struck me as odd that we had a medical practice owned by a physician's assistant without a physician involved, and I think you've answered my question.
So the practice was not owned by my client, the building was. and the practice was ongoing under the supervision of another physician. So when the building was sold, supervision transferred to Dr. Kareem, and that's what landed the employment contract that's in front of you today. The employment contract was a pretty specific document. It called for payments, benefits. It called for the professional care and judgment of the defendant. And it was breached, we believe, by the plaintiff delivering to defendant a notice that he was laid off and that he could apply for unemployment benefits. He became unemployed. The contract did not provide for layoff. It provided for continuing employment, and it provided for termination without cause. And that meant that if the plaintiff wanted to terminate the defendant, he had to meet the liquidated damage portion of the contract. That portion of the contract required 30 days pay plus fringe benefits for 30 days. Instead of delivering the 30 days pay, instead of terminating plaintiff in accordance with the contract, defendant was not terminated in accordance with the contract. The plaintiff simply told defendant, you're done. You're unemployed. Get out of here. And in connection with that, delivered to him a state notice from the unemployment agency that said he was required to be unemployed and to look for work. In doing so, he found a job at Hillsdale Hospital. And that's when this case truly started, because the plaintiff filed an ex parte temporary restraining order to prevent the defendant from going to work in the emergency room at the hospital. The first breach rule is the rule that applies in this case. It's quite simple. If you're going to enforce a contract, you cannot be the first to breach it. The plaintiff had a clear contract with the defendant. It had written terms. If you want to terminate your employee, you have to give them 30 days pay plus their fringe benefits. That's not what happened. They delivered a notice. You're laid off. Your benefits have terminated. You're not going to get any more pay from me. Go apply for unemployment. Now, the first breach rule applies if there's a substantial breach of contract. And in an employment contract, arguably, the paycheck is the big material term of the contract, at least as far as the employee is concerned. And that would be a very significant breach of the contract. It would be akin to this defendant not showing up for work anymore. It would be a unilateral breach of the contract. So in this case, by breaching the contract, by telling the defendant he is unemployed, that he should look for work elsewhere, and not giving him the 30 days liquidated damages required under the contract, the plaintiff breached the contract. Now, the remedy for breach of contract would rest with the defendant, not with the plaintiff. The plaintiff can't simultaneously say, I'm going to breach the contract, and then when you do what I told you to do, I'm going to enforce the contract against you, and I'm going to insist that a preliminary injunction be entered to prevent you from doing what I told you to go do. So it is, in fact, partial summary. There are other parts of the case, but the employment contract is very much out the window. There is no employment contract that existed at the moment that plaintiff breached the contract. Plaintiff could quite easily.
Let me stop you for just a minute, because this has been something I've been curious about. Where is the defendant working currently? I assume he's working somewhere.
He has been employed in Ann Arbor area now, doing the same kind of work, but outside the geographical restriction as placed by the temporary restraining order.
Does he, depending on the outcome of my ruling, have plans to return to Hillsdale? Or is that undecided?
he lost the position that was available to him in April. That was filled. He is qualified to step in. He had to take some additional training in emergency life support, things like that, in order to qualify for that. But he has not sought employment there while the order was entered. And so he's working, doing family care at a clinic in Ann Arbor right now.
All right, so what his future plans are they in part dependent upon my rulings in this case?
Yes, Your Honor.
Okay, thank you. You may continue.
Well, really, I have nothing additional to add, except it seems pretty clear cut to me. You can't breach a contract and rely on it. That's black letter law. It's as old as the state of Michigan. So I think that fact in and of itself renders any other decision today moot, because the court's being asked to enter a preliminary injunction based on a contract that doesn't exist. So if the court grants the summary disposition motion, the plaintiff has no grounds for a preliminary injunction, and the case can proceed on the other areas, the other allegations that exist, but not on the employment contract.
So I remember when we had a scheduling conference, you were arguing that there really isn't a temporary restraining order in place anymore because it expired, notwithstanding the last order that was entered regarding it that said it was going to continue in effect. If indeed there is a temporary restraining order in place, are you also asking the court to dissolve that temporary restraining order?
Yes, I think the plaintiff has not cited the court rule, and they in fact violated the court rule when they got the restraining order. They knew 10 days before they went to get the restraining order that I was representing the defendant. They did not represent to the court at the time they got the restraining order that they had made any effort to communicate with me or my client regarding that order. And that's required. That's a part of the essential requirement of the court rule. Nevertheless, the court entered that order. The court order itself says the preliminary injunction hearing is to be held within 14 days. And that was a very, very long time ago. So I don't believe under the rules of the state of Michigan, that order is still effective. It expired on its own terms 14 days after this court assumed handling of the case.
All right, well, irrespective of how I rule on that particular issue, if there is indeed still, if I rule that there is a restraining order still in effect, you would ask that I set that aside?
Yes, Your Honor.
Okay. For the same reasons you've argued in your motion for partial summary disposition, we can't have a restraining order or a preliminary injunction. Oh, wait a minute, we lost other counsel. I just noticed that.
Dropped off a couple minutes ago.
Yeah, I didn't pick up on it. I was focused on you. She's been gone for a couple minutes now, so we better let her get back in.
Yeah, that's fine, Your Honor. I've had those problems myself from time to time.
We seem to have had a good connection, so
Yeah.
I'm not quite sure why she got bumped off. I'm watching my waiting room to see if she shows up again.
Well, you want to debate the merits of Zoom courtrooms now?
My personal preference is I like Zoom when it's working.
Right.
It's a struggle, obviously, when people have connectivity issues. Although often I'm able to get around those just by establishing a telephone link Fortunately, phones still work. But yeah, when it's working right, I frankly prefer it.
It works fine for motion hearings, but I don't think you can conduct a trial virtually. I just, there's too many variables.
I've done it, and I understand what you're saying. I hear from a lot of attorneys, but from my perspective, as long as I've got a good connection, I can judge demeanor just as well over the video as I can for a person that's sitting at the witness stand. There she is. Get her back in.
While she's connecting, I was very surprised that it was Justice Bernstein at the Supreme Court who had the greatest objection to virtual hearings. And he's not able to see, which I thought was interesting.
Okay, Ms. Oliver, you're back. I don't know what happened, but I was questioning, and I didn't notice immediately when you dropped off. So I was questioning Mr. Morris if understanding his. We don't have her yet. Ms. Oliver, check your audio connections. I might try to dial her phone number if we can make this connection again. Yeah, we've got a video connection, but I don't have an audio. And then they just dropped off again.
I don't know.
Do you happen to know where her office is located?
She has an office in Troy. I don't know where she has an office in California or Texas, I believe. So there is another
Right.
office out of the state of Michigan. I don't know where she is today.
I'm going to try to dial this phone number that's on the pleadings. Oh, we'll try again. Yeah, for some reason, the call's not going through.
I'll try from here, Your Honor. Give it my shot.
I have been having some trouble with this phone, of calls not dialing through. I get an initial dial tone.
Getting a ring now, Your Honor.
Hello?
Took a minute. Yes, this is Christopher Moore calling. I'm with Judge LaFlamme
I'm just trying to call her
here,
up now and
and
it's working.
Do you have her on the phone?
not with us.
Just a moment, please.
All right. Ask her,
Just a moment.
ask her to dial this number.
Sure thing.
Five
Can
517
you dial this number, 517?
768.
Hold on, sorry. The judge wants you to dial in. Can you dial in this number?
Yes.
517 768
768
1610.
1610. Yep, all right.
That was
Sorry for
an
the
answering
inconvenience.
service that I rang through to.
My law clerk had her on the phone, and I've asked her to dial the courtroom. So hopefully we'll be getting a call momentarily. Although my phone, here we go. Ms. Oliver?
Hello, sorry about that.
All right.
Our internet went down in the office, so yeah, but and you guys were frozen on the screen, so I thought we were all just staring at each other for a minute until I realized what happened.
Okay, so let's go back. I was starting to question Mr. Morris about the. He argued during the scheduling conference that we had recently that he didn't believe there was a restraining order in effect and gave reasons for that. And what I asked him, and I don't know how much of this you were able to hear, is assuming that I rule that there is still a restraining order in effect, would you ask me to set that aside for the same reasons that you've argued in support of your motion for partial summary disposition? And his answer to that was yes.
Okay.
No great surprise, but I wanted to make sure I had that clear on the record. So
Thank you.
if you're ready to proceed, I'm ready to hear your arguments in opposition and in support of your own motions.
There's one more element I wanted to voice to the court.
Oh, okay, I'm sorry. Go ahead, Mr. Morris.
Thank you, Your Honor. The other interesting element of this case is that it involves medical care. And there's a somewhat of a dispute in the case law about the delivery of medical care being something that you can limit by a non-compete agreement, because the patients are free to go wherever they wish. They're not they're not a commodity or a product as would normally exist in a business relationship. So there is a line of cases that discusses that. And I think the final element of that is it just doesn't make any sense in the middle of a COVID pandemic to remove a healthcare provider from a community the size of Hillsdale, particularly since the plaintiff has represented that the hospital is a direct competitor to plaintiff's business. And that's simply not the case. That's like saying the Jackson High School football team is a competitor of the Chicago Bears. They're just not the same kind of organization. They don't provide the same kind of care. The emergency room is life support, serious accident. The walk-in clinic that the plaintiff has a walk-in clinic, which is just primary care, just sore throats and that allergies, bee stings, that sort of thing, far different than the emergency care that is delivered by a hospital. The other factor that is involved in that is that the hospital does not retain patients. Patients come to the hospital, they're treated, and they're discharged back to their primary care provider. They do not remain permanent patients of the hospital. So there's not a competition that was being entered into in direct competition with plaintiff's business model.
Okay, thank you.
Thank you, Your Honor. As it relates to the argument that my client first breached this contract and then therefore defendant should be entitled to partial summary disposition on the breach of contract case, I believe that's an erroneous argument and should be denied. First of all, as it relates to the Scribner's error, we sent in the supplemental response to this motion that included the deposition that we took of Mr. Scholl shortly after the case was transferred to Your Honor, and he testified in that deposition that he knew very full well that the non-compete term of the contract applied to him. He acknowledged that he actually wrote that portion of the contract himself. And so in regards to Scribner's error, somehow this Milliken not applying to Mr. Scholl, where his name is listed, I think, 125 times in the document, it doesn't make sense, and it's not supported by the paperwork, and it's certainly not supported by Mr. Scholl's own testimony under oath. In regards to my client being in first breach, a layoff is not the same as a termination. There was no termination of Mr. Scholl's employment at any time. The letter that was sent by my client.
Let me stop you. I have a question for you. I understand it was characterized as a layoff. Is there any provision in this employment agreement that permits the employer to suspend the employee's wages for purposes of a layoff?
The contract is silent on the issue of a layoff. It says nothing one way or the other. It doesn't say he can, it doesn't say he cannot. But this isn't, I don't think, along the same vein as a layoff might be considered in normal times when we're not talking COVID-19 and executive orders from the state. So this layoff was issued to Mr. Scholl and a number of other employees. And the letter terms it directly as a layoff. It says that we're hoping to call you back in 30 days. Please let us know if your contact information changes so that we can get a hold of you when we come to call you back. And that also indicates that the layoff is a result of the COVID-19 situation. The layoff happened immediately after the executive order of Governor Whitmer was put into place and was a result of my client doing everything that he was supposed to do as a business owner to comply with those orders. In fact,
was there anything in the employment agreement that prohibited your client from continuing Mr. Scholl's salary and benefits during the layoff?
No, the contract is completely silent on the issue of a layoff. It is just simply not addressed. The whole situation isn't addressed in the contract. So, our position is my client as a business owner did what he was supposed to do as a result of the executive order of Governor Whitmer. He, in fact, did go to call Mr. Scholl back, I think, in less than a month. If my memory serves me right, I think it was 27 days later. And by that time, Mr. Scholl claimed that he had new employment and had been terminated. He never made any offer to return the $163,000 that my client paid him as part of this deal. And so far as I know, has no intention of giving back that money that he got and is refusing and has refused to come back to work. So that's our position on the issue of whether or not my client is in breach of the contract. If the court were to rule against us on this issue, we would seek leave to amend to add an unjust enrichment count as opposed to a breach of contract count, because most certainly Mr. Scholl wouldn't be permitted to walk away with $163,000 in his pocket. And as a result of layoff that occurred due to executive order of the state government.
Doesn't
and a 27 days.
Doesn't your client,
Pardon me?
Doesn't your client still own this practice?
He does own the practice, but the deal was 5 years plus $163,000. So Mr. Scholder was to work for 5 years, and he was to receive $163,000. He's received $163,000, but he's not worked for the 5 years.
Is your client still conducting a practice at the location where he worked?
Yes.
So I assume.
And Mr. Scholl is welcome to come back to work. He's called back to work many, many months ago and chose not to go back to work. What else do I have to say above and beyond the brief? In regards to whether or not, and I guess it's kind of moving on to the other motion that's before the court and the dissolution of the temporary restraining order. The non-compete portion of the contract provides that Mr. Scholl would not work within a certain towns, and he wouldn't work for any entity that provided pulmonary sleep studies and urgent care. And that's in the four corners of the document. And of course, Mr. Scholl acknowledged that during the course of his deposition that that's the deal that he made. Hillsdale Hospital does provide pulmonary sleep study and urgent care, again, acknowledged by Mr. Scholl. So the argument that that somehow Hillsdale Hospital, because it also provides a hospital of service, is not an entity that would be barred by the non-compete agreement is belied by the actual contract itself and the plain language of that contract, but also Mr. Scholl's acknowledgement under oath that the hospital, in fact, is engaged in those three practice areas that were barred by the non-compete clause. Other than that, Judge, I don't have anything in addition to my pleadings before the court unless you had any questions.
I do not. Anything further, Mr. Morris?
Well, Your Honor, I think that counsel was a little loose with the facts when she described what happened in March. They attached the actual notice. It was dated March 20th, 2020, and it told Mr. Scholl that it has become necessary to reduce its workforce. It told Mr. Scholl to apply for unemployment benefits. It said that his benefits, his fringe benefits, would stop immediately. And the unemployment notice that was attached to that is also part of plaintiff's pleading. And it says that you've become unemployed. So I think there's no question of fact that the notice that plaintiff gave to defendant was that he was unemployed. Finally, the provision of sleep studies and urgent care, that was not what Mr. Scholl was going to do in the emergency room at the hospital. That was not the practice he was hired to join. He was going to provide critical care to patients, not urgent care and not sleep studies, not pulmonary care, only to the extent that life support might require ventilators or other pulmonary support. But it's an entirely different practice.
And I would just be in response to that, Judge. I think the documents speak for themselves. They're attached, and the court most certainly can review all of those things. You know, the non-compete agreement doesn't say, you know, that it depends on what Mr. Scholl does within an organization. It doesn't say anything like that. It says what it says, and it means what it says. That's all I have, Your Honor.
Okay, thank you. I want to address the temporary restraining order first. Had this case been filed before me and the request for a temporary restraining order presented to me, I would have denied it. For two reasons. One, I know enough about hospitals and emergency rooms to know that they are significantly different from a urgent care clinic, a walk-in clinic, and a typical medical practice. I would have had serious doubts as to whether or not there was going to be any real competition, and I would have insisted upon having some kind of a hearing so that I could hear the other side of the story. I also would have denied it because I believe one of the factors that I have to consider when considering extraordinary relief is the impact on the public. And here I would find that even if there were the potential for some violation of a non-compete agreement, that the interest of the public in patients being able to seek care from whoever they choose to seek care from and the interest of the public, particularly during a pandemic, of making sure that a hospital emergency room is fully staffed and adequate to be able to meet the needs of everybody who comes in the door. It's not only would I have denied it as a ex parte temporary restraining order, it's highly unlikely that I would have granted it as a preliminary injunction. In addition, and this goes directly to the motions for partial summary disposition, I do find that the plaintiff first breached this agreement. This agreement makes no provision whatsoever for a unilateral decision by the employer to lay off someone who's been guaranteed employment, or if it's going to be terminated, that it be terminated in a very specific way with a attendant payment and a continuation of benefits. That didn't happen. So I do find that there was a material breach of this agreement by the plaintiff, and because of that first breach, that the defendant cannot seek enforcement of the contract. So I'm going to grant that motion for partial summary disposition. I am also, though, going to give you the opportunity to file an amended complaint under your unjust enrichment or whatever the theory is. I think you ought to have a chance to have that claim heard. So I will grant leave to amend the complaint to state that claim or any other claim that you feel that you have. I am, for the record, clearly dissolving the temporary restraining order. I do find that it continued in effect. These are very unusual times. I recognize what the court rule says about the lifespan that a temporary restraining order is supposed to have. Unfortunately, in practice, it's exceedingly rare that we can get hearings scheduled as quickly as are required by the rule. And in these very unique times where we had courts closed and this COVID hanging over everything, that although had I known there was a restraining order in place and a desire to get it addressed, I would have addressed it. But as you might imagine, when I get a file, whether it comes up from downstairs or whether it comes from another county, unless there's a pending request for relief that's immediately brought to my attention, I typically don't spend a lot of time reviewing the file. It's incumbent upon the attorneys, when you have a file like this, where there's some urgency involved, that you take steps to bring it to the court's attention. But for the record, the restraining order has not been set aside. I am setting it aside today for the reasons that I've already stated. Mr. Morris, you'll prepare an order consistent with my rulings today?
Yes, Your Honor, and I believe you misspoke when you said the defendant cannot rely on the contract. I believe you meant the plaintiff cannot rely on it.
Yes, I'm sorry, I misspoke. You're right.
Just wanted to clarify for the record. I will prepare the order. Thank you, Your Honor.
Okay, thank you. Have a good day.